Hi, this is Vijay Dinakar. In this video, I want to talk about what to do if you're pulled over for a DUI in California. So typically, you will not actually be pulled over for a DUI. Instead, a police officer will observe you driving and see that you've allegedly violated some vehicle code section. So, for instance, speeding, or going through a red light, or making an illegal turn, or weaving in and out of a lane. And then he'll flash his sirens and try to pull you over. Now, at that point, what do you do if you have been drinking? And by the way, it is not illegal if you're 21 and over to drink and then drive in California, but it is illegal to operate a motor vehicle when you're under the influence of alcohol or your blood alcohol level is 0.08 by volume or higher. So if you have consumed some alcohol, what do you do when the officer approaches the vehicle and says license and identification, or says, do you know why I pulled you over, or asks you any other question? You should absolutely not say anything to the police officer in that situation. Instead, you should absolutely have ready your photo ID, your registration, and your insurance card. You should calmly hand that information to the officer, but you should absolutely resist any attempt by the officer to get you to speak. And the reason that's true is that anything you say, if you're eventually arrested for a DUI, can be used against you and will be used against you. So you are, by doing that, foreclosing future DUI defenses, and there are a lot of DUI defenses. The officer will absolutely ask you where you're coming from, how much alcohol and when you've consumed that alcohol, whether you've consumed any food or other liquids with your alcohol, and that, in answering those questions, is going to foreclose defenses, because the law in California is driving under the influence of alcohol or driving with a 0.08 by volume of alcohol or over at the time of driving. So you may be driving, your blood alcohol may be at one level, and by the time you're tested, it could be at another level, and that's because it's been rising. But if you tell the officer that you were drinking at a particular time in the evening or morning and how much you drank, well, now you're foreclosing potential defenses. The second reason you don't want to be answering any or making any kind of statements to the officer is that he is going to be monitoring your speech and claiming that that speech is slurred, or that that speech was confused, or that that speech indicated that you didn't understand the directions that he was giving you by your responses. And again, all of this is being used to prove that you're objectively displaying the symptoms of intoxication, and therefore it's not safe for you to operate a motor vehicle. So instead, you should refuse all attempts by the officer to get you to make any statement. Similarly, you should refuse the officer's request, and it is a request, to perform a preliminary alcohol screening test. So that's basically a handheld breathalyzer machine, which is entirely voluntary to perform. You do not have to perform that. The officer may suggest that it is something you have to do, but it's not. And by doing it, you're supplying the officer with more information to justify his arrest and to justify the prosecution against you. Similarly, you should refuse any request by the officer to perform field sobriety tests. So field sobriety tests are, walk in a straight line, do the alphabet backwards, or do any number of other physical tests which are meant to determine whether you're displaying the objective symptoms of intoxication. You cannot pass those tests, okay? The officer is only going to indicate that you're failing those tests, and that information can be used against you. Now, if you're on probation, you must perform the preliminary alcohol screening device, so you cannot refuse to provide that breathalyzer. But if you're not on DUI probation, you should not perform that. And if the officer is going to arrest you, he's going to arrest you. Now, once you are actually arrested, meaning you're handcuffed, you're transported to the police station, at that point, you must provide either a breath sample or a blood sample. And that's your decision as to which one you want to provide. Blood is certainly more accurate than breath. There are more inherent problems with the breathalyzer machine. There are more potential problems with the breathalyzer operator. However, blood is going to pick up other substances besides alcohol, whereas the breathalyzer is only going to pick up alcohol. So if you've consumed either legal or illegal drugs and you're worried about that turning up, it would not make sense to select the blood sample as the option. And you do have that option. Now, you cannot refuse. If you do refuse, the officer will be able to get a warrant to extract blood from you forcibly, and refusing itself is an enhancement in California. You should absolutely provide a breath or blood sample. You have to once you're at the police station. Now, at some point, you may either be released on your own recognizance, or you may have the option of making a phone call. If you do place a phone call at the police station, you have to remember that that phone call is absolutely recorded. So again, you don't want to be making much in the way of a statement there, because that itself can be used against you in terms of proving that you had slurred speech, or if you're going to be making a phone call and making any kind of admission, that's going to be used against you. Now, once you're released, you got to hire an attorney and you got to fight this case. But if you've done the things that I am suggesting make most amount of sense in terms of not making a statement, you'll be at the greatest advantage in terms of potentially fighting your DUI case. If you have any questions about DUI, let me know. Take care and all the best.